Dr. Bill Chris, legal historian, thank you so much and welcome to Ion Politics.
Thanks very much, Jack.
So, you wrote a book called Six Constitutions Over Texas, and we're talking about the Texas Constitution as it relates to this back and forth battle over redistricting and whether Democrats can break quorum and whether Republicans can actually bring them back through arrest powers to the Texas Capitol. And the Texas Constitution does allow both, right?
Yeah, the Texas Constitution vests in the legislature, each house of the legislature, their own rulemaking ability, including the ability to discipline members and also to compel their attendance.
And when we talk about compelling attendance, that does include physically constraining House or Senate members, in this case, House members, and actively returning them to the Texas Capitol.
Yeah, it can. There's another provision of the Texas Constitution that immunizes legislators from arrest while the legislature is in session. And so it's a little tricky because you can't arrest them, or law enforcement can't arrest them. But the legislature has the ability to compel their attendance, whatever that means. And this has never been litigated in Texas that I'm aware of. So, in terms of what the difference is between being arrested, which is not supposed to happen if you're a legislator when it's in session, and being compelled to attend, uh, nobody's really litigated that. So we don't know what the answer to that question is.
Now, we saw Speaker Dustin Burrows sign what he said were civil arrest warrants. So could that be the distinction here if it's civil?
Yeah, I mean, that's the idea. But then the problem becomes if it's a civil warrant, in what sense would the executive branch be authorized to serve that warrant? What law enforcement authority would exist in order to do that? You would think in a pure form, and here I'm expressing my own opinion. I'm not affiliated with anybody. I'm an independent historian. I'm a scholar. I think what you would normally contemplate in this situation is that moral suasion would get a legislator back to the chamber. So you get a warrant signed by the House Speaker that presumably would be served by some marshal or parliamentarian or sergeant at arms of the House. And as a result of being served with that warrant, the legislator would return, or if they don't return, they'd be held in contempt by the House. And because the Constitution also provides that the House can punish its members.
But can't the House also, in addition to the Sergeant of Arms, ask a Texas DPS? Because we saw the photo that the speaker posted on X of him meeting with DPS leaders to coordinate all this.
Yeah, I mean, technically, if you're going to observe the chain of command, the legislature would ask the governor to ask the DPS to do that. But apparently, that's what they're doing. And we live in a political era where the question always nowadays, which we never used to ask 20 or 50 years ago, is who's going to stop them? Right? So if the DPS goes after them, what is there to stop them? So the problem that we have here, Jack, is that we're partially in charted territory. This sort of thing has been tried before, and it never, sort of actually came to blows, figuratively speaking. But we're in a different era now, where we're in uncharted territory. We've never seen legislators put through a perp walk, so to speak. Will we, in the near future? I don't know.
Now, the governor and the speaker have said that they are trying to actively locate, the Texas DPS is trying to actively locate, and Senator Cornyn says the FBI has agreed to assist the state in locating members who are out of state. So if we did see Texas DPS, physically escorting House members who didn't, who broke quorum back into the House chamber. Would that surprise you?
Would not surprise me in these days and times. If you had asked me that question 30 or 40 years ago, I would say, yes, it surprises me.
But
But we're
but
we're
would they be on
beyond
solid? I'm sorry,
Go
would they
ahead.
be on solid legal ground doing so?
Um, as a lawyer, I always tell people have misconceptions about the law, right? The law is what actually happens. The law is what actually gets enforced. And what's happening now is our political discourse has devolved to such an extent that rather than proceeding based on informal norms and protocols, people on both sides just seek for the most powerful remedy that they can find. And the question they ask is not, gee, let's go search through hundreds of years of legal precedent and decide whether this is a good idea. It's just like, who's going to stop me?
But I do remember now that there was we reported on it, a 2021 opinion by the Texas Supreme Court that said physically restraining somebody, a House member, back to the Texas Capitol is allowed.
Well, it's certainly allowed inside the state borders, right? Inside the borders of the state of Texas. Um, Legally speaking, the question would be, how do you accomplish that? Because it's supposed to be accomplished by the legislative branch. Legislative branch is supposed to govern itself in terms of making and enforcing its own rules. And the 2021 case that you're referring to, which is In re Turner, which is the last time that the Texas Supreme Court has talked about this, in that case, the court failed to intervene or declined to intervene in a unanimous opinion because in that situation, what they determined was that the dispute was not really between the executive branch or the governor and the legislators who broke quorum, but rather it was an internal dispute between two different factions within the legislature. So if that legal precedent is followed, you would expect the Supreme Court to decline to really do much about this situation either. So again, if I have a message, it's sort of that we live in a legal era of free for all. I mean, even if you have legal precedents, as we've seen with the United States Supreme Court, a Supreme Court of any government can decide to change its mind, can decide that it's time to overrule a precedent, even its own precedent. So we're really in uncharted territory here to some extent.
And so the other thing I wanted to ask you is about Governor Abbott's emergency petition to the Texas Supreme Court to try to remove House Democratic Caucus Chair Jean Wu, the Democratic state representative from Houston, and using what's called no, excuse me, a quo warranto provision, I guess, right?
Yeah, it's a quo warranto proceeding. I've
Yeah.
taken a look at the governor's brief in the Supreme Court on that. And most of the brief, or a lot of the brief, the introductory part of the brief deals with the legal authority for the governor to bring such a petition. Petitions for quo warranto are usually brought in the district court of a county where the government official resides or is elected from. The governor is basically relying on some constitutional provisions and some common law history that goes back centuries into England for the proposition that there's really no other remedy provided in the government code for this type of situation, and therefore he should be allowed to file this case in the Texas Supreme Court. That's the standing side of the argument. The merits side of the argument, and here we have some guiding authority that goes back to the 1920s from the Texas Commission of Appeals. The substantive side of that argument is what the governor's claiming is that these legislators have essentially resigned their office, that they've abandoned their office, and that therefore it's not a question of him removing them, they have removed themselves. The problem with that is that the guiding legal authority we have that's about 100 years old is that to accomplish that, you would have to prove to a finder of fact that those legislators left the quorum with the intention of never returning, with the intention of resigning their office. And it seems to me that's going to be a hard thing to prove.
Well, the Democratic lawmakers who have broken quorum I've spoken with have said that they are there fighting, they left to try to protect their constituents and fight back, and that their constituents want them to do this and that they are not abandoning their office.
Well, that's why I say it's going to be difficult to prove, right? The other thing is procedurally, you have to wonder in the Texas Supreme Court, since under Texas law, fact issues, with a few very limited exceptions, fact issues have to be determined by juries. And since the Supreme Court's already held, or the Commission of Appeals already held 100 years ago, that the question of a legislator's intent in breaking quorum is a fact issue. You have the question of, how's the Supreme, there's no procedure really in effect for the Supreme Court to impanel a jury to make these kind of factual determinations.
Could they assign a district court to do that?
I don't know the answer to that. And to some extent, the Supreme Court, since the Supreme Court has control over its own procedures, if the Supreme Court wanted to have a trial in the Supreme Court and wanted to impanel a jury, again, they have control over their own docket. So just the fact that it's unprecedented doesn't mean they can't do it.
Interesting. Well, there's lots to watch over the next couple of days and weeks to see how this goes and how this ends.
Yeah, for independent historians like myself, scholars of the law and of politics, this is a fascinating dispute. It's one that I think is symbolic of how far our political discourse has degenerated from the more polite and protocol-based way that business used to be done.
All right, we will leave it there. Legal historian Dr. Bill Chris, thank you so much. We appreciate it.
Thank you for having me.
You bet.